Next up is John Dickey from the Dallas office of Dykema. John concentrates in securities, corporate finance, antitrust, commercial law, both at the state and federal level, as well as in equity and hedge fund regulation, debt and equity offerings, venture capital financings, mergers and acquisitions, joint ventures, partnerships, and corporate matters. His experience in public and private financings, restructuring, stock splits, spin-offs, regulatory compliance, IP, and strategic alliances. He has also managed commercial and distribution licensing matters throughout the world. John assists clients with complex corporate governance issues. Now, straight from Dallas, the Tony Romo of Regulatory Issues and Trends for Investment Advisors. Please welcome John Dickey.
Thank you, Doris. Well, given the record I expect the Cowboys have this year, I'm not sure I want to be called the Tony Romo of this area. As you can tell, I'm a transactional attorney. I'm not a litigator. Most of what I focus on is compliance, registration, compliance in particular, examinations, internal procedures, audit questions, both public and private. And today what we're going to really focus on, and I say really focus on, is are issues that involve national examination of registered investment advisors and investment companies by the SEC. And want to provide you in a highlighted fashion what to expect now in 2013 and much of what we can expect in 2014 with what the SEC and staff will be looking for when they come to examine the RIAs and investment companies. The big focus that I start with is that much of the examination priorities stem from implementation of the Dodd-Frank Act. Next slide. Here? Okay. What I really want to focus on are the specific NEP priorities that were announced earlier this year. We have some staff comments since then that have further highlighted the priorities, and this is not going to delve into the minutia and the granular particulars of the examination process. It is really designed to highlight what you should be looking for in either advising your clients or if you're a registered investment advisor or investment company, what you expect in the examination process as being what the focus is going to be in the next, I'd say 18 months. The custody rule and the identity theft rules are something I'd like to delve into a little bit more thoroughly if we have an opportunity. I understand that there is a break right after my little talk here, so I will not invade that time, but I would say that in the materials, the written materials, there are plenty of assets and guidance and all of the links that you would need to look those rules up. There's some summaries of those materials. Okay. The NEP priorities that were announced earlier this year in February include some market-wide priorities. These market-wide priorities are what the NEP says that they want to focus on. Now, what's happened in the last 2 years is that there have been a requirement for registration of many private fund advisors. There's some 2,000 new registrants. So one of the priorities of staff is to focus on those new registrants with presence examinations. Now, those presence exams are under the NEP presence exam program, and I included in the materials the actual letter that went out to all the new registrants. They are going to come see you as a new registrant. They're going to focus on your internal procedures regarding disclosures to the fund board and management. They're going to focus on the adequate valuation backup that you have for providing valuation data to the fund managers and directors. They're also going to focus on your internal procedures with regard to your disclosures for any marketing materials. Now, they're looking for deficiencies, they're looking for any inadequacies in those procedures, but more particularly, they are also looking to see that you are adequately staffed, you are adequately staffed with the expertise that you need. It's not just the expertise, but it's also, are you able to deal timely with the compliance measures that are required, particularly disclosures to clients. That includes reporting and the dissemination of adequate audit information and so forth. A couple of other priorities that I'd like to mention. The staff is going to be looking at fraud prevention, mitigation, and what the RIA, whether newly registered or registered historically, whether or not you are complying with the new set of rules. There was and I'll just highlight this, the identity theft red flag rule has been implemented, and the SEC has promulgated an alert earlier this year, and I'm going to touch on some troubling statistics, but I'll mention them here. Nearly all of the red flag rules compliance is driven by what you have in the way of customers, your unique situation, and the SEC has only provided guidance. So there are no forms that exist yet at this point that the SEC has actually reviewed. So many of these exams are going to be looking at the adequacy of your analysis of the facts of your unique situation as an investment advisor and your implementation to develop your own policies and procedures. I don't know about you, but that seems to be a pretty scary proposition when the examiner's sitting there looking at your policies and procedures to see if they are adequate or not. When you have lengthy guidance, but it's really the application of that guidance to your specific facts, you're going to need to defend your position in the examination process, is what I would say at this point. Conflicts of interest. NEP is really focusing on two levels of conflicts of interest. The first level is in the compensation schemes that RIAs have, particularly in connection with affiliates and non-affiliates and service providers and vendors. They are also looking at disclosures of those conflicts of interest to clients. Are those disclosures compliant? Are they complete, timely, and are they accurate? That is what staff is looking at. And in the guidance, and their announced guidance over the last 3 years in particular, they are looking at the conflicts of interest disclosures because many of those disclosures failed to comply with a sort of a full-throated, fully developed disclosure of the actual conflicts of interest. And it's not that you can't have a conflict of interest in some situations, it's the fact that you are required to disclose them. And some of the failings come from failure, some of the compliance failings come from the failure to actually discern that you have an actual conflict of interest that needs to be disclosed. Staff is going to focus on that in greater detail in the next 18 months or so. They've already started this year. I've had a couple of clients in the examination process who had received, one was an untimely, another was inadequate disclosure. I'd like to mention briefly technology. One of the other things that staff is looking at for RIAs, particularly focused on the newly registered investment advisors, but also investment companies, is the technology capabilities that are being employed, particularly with data integrity and security, particularly with access and with an eye toward protecting customer information and client information, and with service provider agreements requiring compliance. So one of the gaps that they've identified is that you have an IT function that's been outsourced and the agreement is not up to date, isn't requiring adequate protections. This is all toward an initiative that is driven by the public perception, and we heard early on that many of the critics say that investor confidence is greatly affected about the protection and security of their investment information. It's also about the accessibility and whether or not it is stable. In other words, your reporting in a public sense and in a private sense is going to be accurate and timely based upon your IT systems. So staff is really also including that in their examination process, and I would say if you're a newly registered IRA, that's going to be a major issue coupled with the adequacy of the expertise and the actual staffing that you have to provide the services to your client in that particular area. Some of the program-specific areas, touch the highlight here. We've covered the new registrants under the present exam process, but the safety of assets, particularly under the custody rule, is a major focus. Now, I'm going to cover that in a little more detail if we have time this morning, but I would like to say at this point that it is one of the chief priorities in the examination process. And there are a couple of great examples that I'll go over here in a minute, but there are occasions, particularly with RIAs that are not large institutional investment advisor connected. You're not in a large investment advisor firm. They're finding, staff is finding in many occasions that the protection of client assets is wholly inadequate. And I got a couple of great and one personal example that I'll go over here in a minute. But I highlight that is a top priority in the examination process. Again, conflict of interest and compensation arrangements. I would like to add to my prior comment by saying that they really are focusing on the compensation arrangements between different clients. You have a situation where the playing field is not level in the way that RIAs are taking compensation from different clients. You've got different deals. And staff is looking at and seeking to verify that you are blind as to those compensation particulars when making your investment advice to various clients. And particularly in your disclosures, you're not favoring one client over another, and so forth. So you may have a better deal with one group of clients than you do others. They do not want to see a differentiation in your approach in giving your investment advice or providing those services. It's okay to have different contractual arrangements and different levels of service that are actually being compensated for. That's not what they're looking at. If they're relatively equal service descriptions, the scope and descriptions, they don't want you to be openly favoring one group over another in providing your services based solely on, or at least by perception, on the fact that you have a different compensation structure. And they're really going to be looking at that very closely in the next 18 months, because that appears to be, and particularly with the advent of registration of private RIAs, private fund investment advisors, that some of those situations now are public perception that you can invest in those private funds and you're not getting the same advice on investments as they are giving to another fund that same advisor is providing advice to. And that's, I think, a public perception that has some root in the media and in some root, in some foundation in some anecdotal experiences of many of the investors that we see serviced. The last item I'd like to really cover and highlight for you is fund governance. To put it mildly, staff is, with the advent of new private fund investment advisor registrations, really looking at the information that is being disclosed, the scope and accuracy that is being disclosed to fund management and from the investment advisor. And if it is misleading, is not timely made, and I have one client on an examination this summer where we haven't received the SEC letter, staff letter at this point, but we actually had a comment from the examiner about this concern. It was related to me by my client, that staff actually commented that the information was untimely provided to the board of directors of the fund, that it was delayed and maybe purposely. That was a perception. I don't think it's borne out by the facts, but they are. I know by experience, recent experience, that this is something that's now in their priority list, that they are also looking at the timeliness, not only the adequacy of the disclosures in a private fund situation. It's very interesting. About 2 or 3 minutes? Okay. Well, let me give you one last parting shot. Okay. Trying to back up here. Let me get to the slide. One last parting shot has been some developments with regard to the division of management. And there are some particular short-term priorities that they've announced. And the one I would really like to mention, it's very, very important that the Division of Management, the SEC staff, on their examination process, looking at what you have as backup for your advice on valuation, for your services regarding valuing assets. That is very important that you have that properly documented for review. And with that, I'm out of time, and I don't want to interrupt your coffee time, so I appreciate your time, and see you on the break.